Thanks, Earl. So I'm going to talk about Paveit. So this is a small company out in Alberta. They wanted to come up with a process to use a mobile mixer developed by a separate company to reach remote sites and apply this mobile roller compacted concrete. Um, so the key thing here is determining whether this was experimental development, and we'll see that they lost similar to Vortex. So their idea was that this mobile mixer um, would solve the problem of transporting this concrete from fixed sites where during that transportation the crystals that form are degraded. So they wanted to come up with a process where they're using lower water content to improve the strength, where this is a typical or a difficult concrete to apply. It's harder to mix and lay. Um, so they're testing the durability of the machine, the maintenance of it, and safety, along with the mix formulations to apply this on site. So there's good potential for improvement here, but does it meet technological advancement? We'll see that the courts disagreed with this. Um, the claimant did not bring in an expert witness to support the innovations, which was really needed to substantiate beyond their existing claims. So we needed to distinguish here what the gaps were in the existing knowledge versus the argued process breakthroughs. So really they were tasked with rebutting the CRA's assumptions, and the burden was put on the taxpayer to prove the existence of shred in this case. So they really relied on a guide for optimizing for this type of concrete. And we'll see that the appellant had issues in cross-examination. For example, they admitted that they didn't read all of the guide. They did have a representative, but the representative was considered a advocate and not an objective witness. And they lacked the objective proof to really make their case. So these were real world applications of the process they were trying to develop. And so their testing was limited. They only had standard strength testing of their new process. They really focused on the low water use and faster compaction as the unique aspects of the project. But these were considered routine by the courts, and this was really backed up by the lack of evidence that they had gone beyond routine optimizations to provide a technological advancement. So this was really just figuring out how to do this on site, a business advancement, but without evidence of publications or anything like that. It was considered by the courts to not be a technological advancement and fell within the guide. And really what it fell apart on is the documentation. So they were unable to demonstrate that they had a systematic process in this case. They really only kept some journal entries and didn't really show the systematic process. So this is really essential. We've seen this under Northwest Hydraulic, that we need to prove there's a hypothesis, systematic method, results analysis, and so on. And just relying on the defendant to make their case, they couldn't back it up with significant evidence. So this is a common pitfall in the industry, especially when you're doing this on commercial sites. You want the evidence of the scientific work. So in this case, we see that the onus is really on the on Paveit to disprove CRA's assumptions. The CRA didn't bring in an expert witness, and were able to get some key admissions from the cross-examination. So we've seen this as CRA's approach when the taxpayer evidence is weak. And yeah, so the cross-examination really didn't go well for the appellant. The judge commented that they were honest and candid, even when admitting unhelpful facts. And again, without the documentation, that's all they had to rely on. Again, we see that the ministerial assumptions were presumed correct, and the taxpayer failed to disprove those. They didn't have a hypothesis that they can articulate, and essentially it fell apart on all 5 criteria. And so both sides really relied on the guide as the key piece of evidence, and it ended up working against Paveit because they essentially followed what was in the guide. There was some indication that they went beyond it in terms of efforts to retain moisture, but it wasn't enough. They saw that they were working within the parameters outlined in the guides. So they really need to show how it goes beyond those indicators in the guide or the standard practice for it to be shred. So the CRA really focused on exploiting gaps in the case rather than presenting why it wasn't shred. And so the takeaway in this that it really needs to be a robust claim. Again, bringing in experts can help give an objective view on the standard practice to be able to withstand that scrutiny. So key takeaways, we've got an example here of what is trial and error in field testing, and especially when it's commercial field testing. There really needs to be evidence that you are controlling variables, right? You're there out in the field. It's really hard to keep track of what's changing considering the weather and the amount of variables involved. So we need strong evidence that this field testing involves the hypothesis and systematic testing and so on, and that there is a knowledge gap in what they're trying to achieve.